Hello, good morning, and welcome this morning to this webinar hosted by the Spain-US Chamber of Commerce and from Greenberg Traurig. It's a pleasure today to have such a great group of panelists to discuss something that is very interesting for Spanish companies these days. Today we're going to talk about fundamental considerations about investing in the United States for Spanish companies, including medium and small size businesses and investors, with an emphasis on corporate and tax considerations. This year has been a difficult year for everyone. Every country in the world has been hit, but somehow business kept going. For many companies in Spain, they were thinking about investing in the United States. And with everything that had happened in this year, well, some doubts came up, and I thought that talking about this would be a good thing for everyone. So before I introduce our panelists today, I will just remind everyone that from the Spain-US Chamber of Commerce, we are hosting a number of activities online at this moment. And I encourage you to visit our website, which is spainuschamber.com, to check all the activities that are coming in the next weeks. Also today, we are going to share the presentation that you will see, and also we will share the video to all the attendees. So if you need to see something again or to share it with friends and colleagues, you will be able to do that. The presentation will take around 45 to 50 minutes, and after that, we will leave a space for Q&A. So anyone that would like to send questions to our panelists, please feel free to do so through the control panel that you might see on your right side. There's a tab that says questions. You only need to click there and send your question anytime during the webinar. You don't need to wait until the end. You can send your questions during the webinar, and we will address all of them at the end, in the Q&A part. So without further ado, I would like to thank Greenberg Traurig for making this happen and for being here with us today with this great group of panelists. So for those of you that doesn't know the firm, Greenberg Traurig has more than 2,200 attorneys in 40 offices in the United States, Latin America, Europe, Asia, and the Middle East. The firm's lawyers help clients bridge diverse legal systems and cultures with a focus on efficient, effective strategic advice and legal services. Antonio Peña, a shareholder at Greenberg Traurig's Miami office, who leads the firm foreign law clerk program, has broad experience in the US, Spain, and Latin America, representing strategic investors and private equity funds in cross-border merge acquisitions, joint ventures, financing, and restructuring, and other corporate matters. And as a matter of fact, Antonio, it's a lawyer in Spain and also here in the US. We have also with us today Jeanette Faust, which is co-chair of the Miami tax practice, focus her practice on tax law with an emphasis on international and cross-border tax issues. We have also Josel Ibarra, co-managing shareholder of Greenberg Traurig's Miami office, represents clients on international corporate transactions, including multinational corporations and prominent Latin American investors. And we have also today with us Cara Bombach, a shareholder in the Washington, D.C. office that assists companies and organizations to lawfully export goods, technology, and services around the world. So, as I said, I think that we have a great group of people that today will explain us the mysteries and the to-dos and not to-do in order to invest in the United States. So, Antonio, the floor is yours.
Juan Carlos, thank you very much. Good morning, everyone. It's a pleasure to be here with you. And we have a very talented group of my colleagues here with Cara, Yosbel, and Jeanette, who will address this topic from different perspectives. And so before I hand it over to Jeanette, who would start, from the tax perspective, we always say that everything starts with tax. We wanted to explain why, we thought this presentation made sense. it was not too long ago. It's almost like deja vu from the 2008 financial crisis, when we saw a significant amount of investment from Spain into the US and Latin America, primarily from medium-sized and smaller firms, or even at times significant companies, but companies that had been more focused on the Spanish market or at times the European market. And a lot of that was prompted by a need to survive or to adapt to the difficulties that arose as a result of that crisis, which was more of a financially driven crisis. It was different than the one we're living now. But now that we're suffering again another significant economic recession, really, this time driven by a pandemic, we've seen, again, from Spanish companies, a quick reaction, and we thought it made sense to share some of that with you, and then in connection with that, provide some advice from the different legal areas as to how we think it makes sense for Spanish companies and investors to consider their move or their expansion into other potential businesses in the United States. What we've seen now is, as you know, because of the need to social distance and the lack of social interaction, technologies have taken a significant role now in the way we do business and the way we interact. And we were talking about that before, Juan Carlos, even the way the chamber's operating today. And a lot of companies now, knowing that we've known for many years that you had to make a shift from retail to have a broader e-commerce platform, or that you had to invest in different technologies to make sure that you would adapt to the different trends and needs. All of a sudden, because of the pandemic, abruptly are required to decide and act. And we've seen that. And we've seen that in companies that are trying to understand different models, business models, and different ways to do business, and with companies that want to have access to different technologies. And that, obviously, we've seen it through investments of handled in different ways, and we're going to talk about some of them today. So Jeanette will help us understand, in connection with these investments, some of the reminders for Spanish companies and investors with respect to our tax regime, our complicated tax regime, and things to consider, and then point out certain trends she's seeing as well under the circumstances, so that we can then hand it over to Yosbel, who will talk about some of the vehicles and some of the ways that these investors are doing business. And then, because of our regulatory regime now, things that were merely theoretical, and Kara, you may criticize me if you want for some of the things I will say, but some of the things that were merely theoretical, like CIFIs, are now extremely relevant. Every investment into technology, or every investment into the United States, may have implications for many different perspectives, including national security. And we've seen it on many transactions. Some of them which are getting delayed significantly if you don't consider that up front. So Kara will help us navigate those difficult waters, and maybe will give us some predictions in connection with the incoming administration, and whether we think some of those rules will change or not. So thank you again for having us, and I'll hand it over to Jeanette so she can talk about tax. Thank you.
Thank you, Antonio. So I'm going to talk to you very briefly on a very high level about U.S. tax considerations, since I don't want to bore you to tears and have you leave the presentation before we get to my colleagues' potentially more interesting topics. So generally, from a tax perspective, I want to cover who, what, and how of the U.S. federal income tax system. So who pays federal income taxes in the U.S., what income is subject to federal income tax in the United States, and how is that income taxed? It's important to keep in mind that while we have a federal tax system here, we also have 50 different states, and just how you see that, and maybe you read in the news that the different states are handling the coronavirus pandemic differently, the different states can also handle the way that they tax income for the residents of their state differently. So On top of there being a federal tax system, we also have 50 states with different state tax systems that can affect how income from that state is taxed. So it's important to keep that in mind and talk about that with your tax advisor when you are planning what your investments in the US and how you want to structure those. I'm not going to talk about the different state tax implications today, so I'm just going to talk about federal tax, but I wanted to point that out so that you're aware and keep that in mind when you're planning your investments in the US. Another warning, not to start with a bunch of warnings, is that the US tax system is very complicated. So I'm going to talk in generalities, and I'm going to give you some information about the US tax system, but this is not an all-encompassing presentation. This touches on some issues from a high-level perspective, but it really is important when it comes to tax to talk with your advisor and make sure that whatever structure you're using is tax efficient for you, and that you're also reporting that correctly in the US. So can we go on to the next slide? And then the next one, that's my warning, so beware. So the first slide, who pays US federal income tax? Well, the answer is both US people and non-US people can be subject to income tax in the US. The way that those people are taxed is different, which we're going to talk about in a moment. So the how and what income is subject to tax differs for US and non-US people, but both people that are US and non-US can be subject to US federal income tax. So an important first question is who is a US person? In the case of an individual, a US person is a citizen, a long-term, a lawful permanent resident, which is an individual that has a green card, and that is also someone that is passes the substantial presence test. And the substantial presence test gauges how many days you're spending in the US. So any individual that is present in the US for 183 days or more in a given tax year, or any individual that meets a certain formula, and we'll show it on the next slide, that looking at the current year and the prior 2 years, if the sum of the number of days during that period is 183, thank you, then you can also be a US US resident for income tax purposes. Then also we have to think about companies too, because companies have a different test than individuals to determine their residence. So a company is considered a US tax resident. You can just wait there. A company is considered a US tax resident if they are formed in the US. So it's a really simple test. If the company's organized in the US, it's considered a US income tax resident. Now, that doesn't necessarily mean that that company itself is subject to US income tax, because different companies are taxed differently. Some companies themselves are subject to tax, and in that case, that is a corporation. And the name corporation is a little bit, that's a federal income tax term, so it can be a little bit misleading, because some companies that are not corps can also be taxed like a corporation. But for federal income tax purposes, a company that is a corporation pays tax in the US. Some companies are transparent, and those companies might have filing requirements in the US, but the way that they're taxed often depends on how the residence of their owners. So frequently that can be a company like an LLC or an LP. Those companies may be US tax residents, but the income of those companies might flow through the entity up to the owners of the company. And then we would determine how the income is taxed based on the residence of the owner. We also have trusts, which I'm not going to get into too much because that's not a commonly used entity with Spanish people, because trusts don't have a very clear definition of how they're taxed in Spain. So it's not the most common type of entity to use when structuring for Spanish individuals, but trusts are treated differently generally than business entities. So that's kind of a general list of who is a US person for income tax. purposes. Then the question is who is not a US person? Well, anyone that I didn't list in that explanation is a non-US person. So we also call that a non-resident if we're speaking from the perspective of someone in the United States. So if I say a non-US person or a foreign person, that's because we use the terminology that is US centric since we're located here. The slide that we're on right now is just a very brief explanation of something called the substantial presence test, which is the look back rule that can apply to individuals to determine how they're taxed, if they're going to be US income tax residents or not. So if you are spending a significant amount of time in the US, it is important to count your days. It's also important to count your days looking in the current year and the prior 2 years. So a rule of thumb that we often tell clients is if you don't spend more than 122 days in the US in a given year, you will not be a resident under the substantial presence test using this look back rule. So that's kind of just a rule of thumb. The way that you count your days is very technical, so it's also important to talk with an advisor to make sure that you're counting your days correctly. But I don't really have time to get into that, so it's just I want to bring that to your attention. Go to the next slide. So what I told you about US residency for individuals, green card, citizenship, days of presence, there are some actually exceptions to those rules. And there's many exceptions I'm not going to go into, but 3 useful exceptions are that for certain F visa holders, and those are students, if they hold an F visa for only a certain number of years, they actually can exempt the days that they spend in the US while on an F visa. Another good exception is something called the closer connection exception. That is only an exception for people to not be a resident based on the number of days that they are spending in the US. And that also goes for the F visa holder, because obviously if you have a visa, you're not a green card holder or a citizen. But the closer connection exception is only for people that are spending less than 183 days in the US in a given year, and they also have certain types of connections to a country outside the US. So in that case, you may be able to file a special form to avoid becoming a US income tax resident. And the last exception is being a dual resident under a tax treaty. And the US and Spain have an income tax treaty. So for people that are Spanish citizens or residents, it may be possible to avoid becoming a US income tax resident by relying on the US-Spanish treaty. So this is an important exception for people living in a treaty jurisdiction, one, because it actually can be used by green card holders and people that spend 183 days or more in the US in a given year. However, it's important to note that with that exception, you actually still have to file international information reporting forms with the IRS in the same way that a resident of the United States does. And those forms are, there's a lot of information you have to include, and also there are high penalties that go along with that. So to the extent that you're able to avoid residency under the closer connection exception versus an income tax treaty, you would generally prefer to use the tax treaty. Another important thing to point out when using a tax treaty is that if you are a long-term resident, meaning you've held a green card in any 8 of the prior 15 years, if you claim to be a non-resident under the tax treaty, that is actually considered as expatriating from a tax perspective. So certain people, when they expatriate, actually can be subject to a tax, and they would have to realize all of any built-in gains in their assets. And there's other kind of negative issues going along with expatriation for some long-term residents. So if you have had a green card for a significant period of time before deciding to stop being a US income tax resident by relying on the treaty, you would want to discuss that with a tax advisor to make sure that you're not going to be considered as expatriating. So let's go to the next slide. So what income is subject to federal income tax? In the case of a US person, it's your worldwide income. I mean, it's your worldwide income. It can also, all the income you receive, it can also be accumulated income or undistributed income from certain foreign subsidiaries that you may own. So US persons really are subject to, a broad scope of income tax, and it is important for anyone that is a US person to be consulting with a tax advisor to make sure that they're complying with their requirements to file in the US. So that being said, how are non-US people taxed? Non-US people are generally taxed on two types of income. Income that we call FDAPI, or fixed, determinal, annual, or periodic income, and that is generally rents, royalties, dividends, interest, can also be capital gains, and some types of service income. And those types of income, the FDAP income or the fixed income, is subject to a tax by a withholding at the source. So if you receive a dividend from a US company, the income tax is actually paid by a withholding that the US company will do on the dividend income, and they will remit the payment directly to the IRS. You don't have to file anything with the IRS, and you don't have to pay anything. What's important for Spanish companies and Spanish residents is that because the US has a tax treaty, the withholding rate on this type of income is a lot less than it is for people that live in other jurisdictions that don't have a tax treaty. So generally, if you're not in a treaty jurisdiction, the withholding tax is going to be 30%. On that type of income, except for capital gains. But for people that are considered residents of Spain under the treaty, the dividend withholding rate goes from 0 to 15%. It's 0% for certain types of pension funds, also certain types of parent companies that have 80% interest, and then it goes to 15 depending on if you have if you're an individual or you have less than 80%. Interest and royalties and interest, royalties, and capital gains are not subject to any withholding tax. So actually there's a 0% tax. So that's kind of an important thing to think about when structuring a fund investment, when you realize that interest from US sources paid from US companies is going to have a 0% withholding, but a dividend maybe have a 10 or 15% withholding, that when you're investing in the US, you may consider investing partially with debt and partially with equity so that you can take advantage of the 0% withholding rate on interest. Let's go to the next slide since I don't have too much time and I want to be able to talk a little bit about the structures. So business entities, which is generally the way that most non-US people, most people in Spain are going to be investing into the US, is through a business entity. Business entities are taxed in different ways. So we can have a corporation, or we could have a pass-through entity. Corporations are generally Incs or Corps if it's a US company, or it is a non-US company where the members have unlimited liability. For example, a Sociedad Anónima or an SRL, those types of things are going to be default to corporations. Then entities like LLCs or LPs, those are going to be pass-through entities. And then a non-US company that where one of the members has unlimited liability will be a pass-through company. So sometimes you have to look under local law and talk to your Spanish advisors to see, is your company going to be considered a pass-through or a corporation for US purposes. There is a way with some companies to file an election with the IRS to actually change their classification. So you could use a company, for example, that is an LLC and by default a pass-through, and you could actually convert it to a corporation for tax purposes by filing a form with the IRS. So that's a really neat way that we can do planning for people without actually having to do anything too complicated with changing the company and the structure. So when you are, I know that my colleagues are going to talk a little bit about fund investments, but I think when you're thinking about how you're going to invest in the US, you might be thinking, am I going to invest personally into a fund? Am I going to invest through a Spanish company? Am I going to invest through or another type of entity? And a lot of that is going to depend on how the fund itself is set up and also what the fund is invested in. So for example, and also it even gets more complicated because you might have a fund where the entity you invest in is an LLC or an LP, and it's a pass-through, but that entity itself is invested in U.S. corporations. So maybe we would treat that a little bit differently than another type of fund that is invested directly into business in the U.S. or real estate in the U.S. So one important thing I think to keep in mind is for when you're thinking about the type of entity is if the fund you're investing in is either a U.S. corporation or is invested in U.S. corporations, you may want to invest directly with a foreign company. If the fund is not a corporation and the fund is invested into corporations, so you have an LLC that's invested into US Corps, you might want to set up a US company that is owned by your foreign company that then invests into the fund. And the reason that you change the structure is, one, we are always thinking about whether we want to have our foreign person or foreign company file a tax return in the US. We want to give you the option to use debt financing, like we talked about, where debt financing may give you the possibility of having a 0% withholding on interest. So that's a really good way to invest into a fund, is to use either debt financing into the fund, if the fund itself might be set up that way to enable that type of financing, or you can do that with your own structure that invests into the fund. And then also in these types of structures, it might enable you to actually reduce your withholding rate, because you can on dividends, because you can control the percent of the ownership, your percent of ownership in the US entity that you invest in. So if you invest into a domestic company and you own 80% or more, you'll have a 0% withholding on dividends, versus if you invest in a US entity and you own less than 80%, you might have a 0 or 10%, depending how much you own. So I am sorry, I'm going to have to stop there. I have so many other things I would like to tell you, but I hope you feel free to call me or email me, and I'd be happy to discuss this with you further. But I want to give my colleagues time to go on, so I'm going to cut up there and move on to the next.
Great, thank you, Jeanette. So if you take away anything from this, and I think I'm going to say it a couple of times, is that you need someone like Jeanette when you're looking at all these considerations that is practical, because there's so many possible combinations that you could really go down a rabbit hole. I wanted to talk just sort of overview of what we're seeing in investments in recently, and particularly focus on two things: fund investments and venture capital investments. And just for a little bit of background, I've been practicing law 22 years now, so I've seen the tech crunch, I've seen obviously the financial crisis during 2008, 2009, and now we're facing COVID. In the tech crunch, just sort of classic economic crisis, a massive devaluation of assets in the technology space. We saw a lot of investment going in at sort of very high valuations, and then right after a severe devaluation of those assets. I think it's also important that in 2001, not only did we have the tech crunch, but there was also the Argentina crisis. And I want to mention that because when we look about fund investments and how these funds are structured today, what comes to my mind is what happened to all of those clients that I did work for, who were invested in funds that were heavily invested in places like Argentina. So you really have to start thinking about diversification and really like knowledge of local economies. During the Great Recession, Antonio said it best. The asset values here in the U.S. plummeted. And as they did in many parts of the world, and Spain in particular, we saw a lot of Spanish companies that saw their markets basically fall away, and they came to the U.S. taking advantage of the fact that the U.S. was, the values were so depressed. A lot of strategic investments were being made at the time into the U.S. Now with the COVID pandemic, it's this very strange situation where the trends that I think we were seeing prior to the pandemic, so innovation, a resurgence of investments in technology, really became hyper accelerated because of what we're going through, right? Like companies that, you know, the delivery companies that implement technology for these types of businesses have really skyrocketed. No one knew what Zoom was before, and now, of course, you know, we're doing thousands of these Zoom calls per day. So again, the focus really has been, I think, on, you know, sort of like what's the next big thing, and we've seen generally, you know, two models or two ways to getting to that new technology. Primarily what we've seen are you know, strategic investors who are looking to find the next new technology. You know, some of them are looking for that unicorn investment, but I think most are really just trying to become innovative and using these tools as a way to innovate. So again, the typical models that you saw before, where you had you know, perhaps an investment manager raising a fund, maybe on a specific geography or industry, are really now becoming partnerships where a strategic that really knows a specific industry might be partnering with capital and investment managers to seek out a specific technology or innovation for their business. So again, the two main things that I want to focus on are funds. So, you know, everyone kind of knows that a fund, you know, capital comes in and it's deployed across several investments. They have the fund has a finite life, and obviously you get diversification there. You have access to various targets. And obviously you have the investment manager who's has this expertise. And as I said, these investment managers are now teaming up with strategic investors who really know the business that the fund is focusing on. And then the other approach is just traditional venture capital, where investors are making a direct investment in specific companies. And that's sort of a more traditional investment where they might get some governance input, and again, give them access to these technologies. And there are some, you know, some considerations that I want to mention quickly. You know, either in the fund investment or the venture capital investment, what we've seen most recently are what I like to say, not shotgun approach. So I'm going to take, you know, form $100 million and I'm going to put $1 million in 100 different companies and hope that one of them is that unicorn, right? It's more sort of smaller or less capital, smaller investments, but in strategic investments, mostly to develop technologies. Next slide, please. Great. So, you know, just want to mention generally funds, and I don't want to go into, you know, too much detail, but I will tell you this, and I'm going to excuse myself to my partner Jeanette, but you know, I have discovered that fund lawyers are like tax lawyers, right? You have to make sure that you find one that is very practical, because you could go down all sorts of structures, right? You know, just like you don't want your tax lawyer setting you up in like 3 different, you know, an Isle of Man company, through a Singapore holding company, through a Dutch company. There are so many variations to how you form a fund that you could sort of lose yourself if you don't talk specifically to someone who kind of does this and know what your objectives are before you start. Obviously, in a fund, the typical structure is a general partner, which is the one that has the day-to-day management of the fund, and then the limited partners are really silent investors that put up capital and have very limited governance rights, if any. The 2 main issues to look at, and Antonio said it again, you know, the first thing you start off with is tax. You got to make sure that looking at where your investors are coming from and what you're investing in is in a tax efficient structure. We generally see structures in common law jurisdictions, so the United States, Canada, some of the offshore jurisdictions like BVI and Cayman. And then the other thing you have to be worried about is regulatory issues, right? If you set up your investment manager in the United States, there are certain registration requirements that you may want to avoid. There are federal registration requirements. There are state registration requirements depending on where you are. So it becomes a somewhat complicated analysis. There are exemptions, but that's sort of the starting off point. Again, I mentioned the funds can be targeted, which we've seen more of that. As opposed to more diversified, and there are limitations on funds, whether it's industry, geography, type of investment, whether they're going to allow for leverage or not. The main governing document of these entities are a limited partnership agreement or something similar, and then a management agreement usually entered into with an investment manager. The fees are management fees, we've seen generally, 1 to 2%. There might be of committed capital stepping down once the investment period is over for these funds. There is a battle really going on between the sort of the American waterfall approach or the European waterfall. An American waterfall on distributions basically is on an investment per investment basis with some sort of clawback in case you sort of hit it out of the park on one and not on others. A European waterfall, sort of more traditional, looking at all the investments of the fund. There are innumerable number of considerations. Do we have an advisory committee, which is basically a group of our investors that might opine on things like conflicts of interest, or whether to make a reinvestment or not. Things like side letters, where you have things like most favored nation clauses. And the one thing I would sort of caution on that, and something that we've come across, is that if you're having strategics as your investors in the fund, companies are probably going to want some sort of non-compete provisions, and some people will want variations from that non-compete. So you got to take that into account when you're considering these side letters. It's one thing when all your investors are a big pension fund or something like that. It's quite different if your investor is an operating company that's looking for technologies. Next slide, please. Great. So the other structure that is obviously very prevalent is venture capital investments, and in the U.S. We're lucky because to a large extent these investments have been standardized. There's the National Venture Capital Association, which if you don't know it, you should go to their website, take a look. They have all standard documents for these types of investments, and that creates a certain sort of baseline that makes these investments easier to approach, because the negotiation is sort of laid out. I will tell you that I know we're talking about investments in the US, but when you're talking about investments in venture capital in places like Latin America, for example, it becomes a lot more complicated because there isn't that sort of standardization for the most part. I'm not going to go into the details of all of these controls, but generally, you put in equity or you put in a convertible debt, which is basically a promissory note that converts into equity upon the occurrence of X or Y. It could be mandatory or not. And the one thing I would say is, if you're the one looking for capital, and I'll leave it on this, but if you're the one looking for capital, it is so important that you set up your corporate governance from the beginning in the proper way, because if you don't structure your company correctly, and you, for example, enter into some shareholders agreement that is completely out of line with what an investor would expect to see, you're going to have a very difficult time raising funds. So happy to answer any questions, but with that, I turn it over to my colleague, Kara.
Great, thanks, Josbel. I'm going to spend the bulk of my minutes talking about national security review on foreign investment into the United States, because that's really sort of where the action is, I think, especially for this group. But before I do that, I just want to spend a couple of minutes to give you an update on economic sanctions, US economic sanctions, and how those come into play when you're contemplating new investment in the United States. Both from a jurisdictional standpoint, because if you're investing in or forming US entities, the US entities and people who are employees of those entities will be subject to US law and required to comply with economic sanctions, and also anyone who's physically located in the United States. So even as non-US person or representatives of a non-US company, when you're physically present in the United States, and granted, I realize most people are not traveling in US to Europe, travel and vice versa is heavily restricted right now, but that's another thing to think about. The other reason I like to flag it is that economic sanctions in M&A investments is a really important area of due diligence, because there is potential successor liability if a target of investment has committed violations of US economic sanctions. And in some cases, even there may be a need to seek authorizations from the US Treasury Department to unwind certain activities, or to have pretty quick post-closing integration activities, either in the form of internal reviews, internal investigations, potentially even voluntary disclosures to US government agencies. So I just want to flag that economic sanctions that are primarily administered by the Office of Foreign Assets Control, or OFAC, are an important thing to think about if you're in the diligence phase, and as you may sort of newly become subject to US jurisdiction via investments. On the bottom portion of this slide, I'll just hit these highlights, and then we can move on to the next point. I think the biggest risk areas for economic sanctions violations, as I mentioned, there's potential successor liability. Violations are subject to both potentially or either civil monetary fines or criminal fines, and in the cases of very egregious willful conduct, even imprisonment for individuals who were involved in the conduct. It can certainly lead to loss of business contracts and impact on commercial relationships. As many of you have probably experienced, and I know there's a lot of sort of a trend in Europe as well, especially amongst the large financial institutions, to require compliance commitments from folks who want to enter into a contract or open an account or whatever it might be, where you're being asked to make representations about dealings either with sanctioned countries or individuals who may or may not be sanctioned. So it's very much the same here in the United States, and quite frankly, a lot of the compliance pressure that we see in European multinationals is a fear or a concern about actual enforcement action by OFAC, by the US regulators. So it's all very much interrelated. The other risk is that even for entirely non-US entities operating outside the United States, there's the potential of what we call secondary sanctions for non-US people who are determined by the US government to be providing some sort of material support or assistance to somebody who is sanctioned by the US government. And so the net effect there is that it wouldn't be a traditional enforcement action in the sense of monetary fines or trying to assert sort of criminal jurisdiction over a foreign entity or individual, but the foreign person, non-US person or entity itself could become the target of sanctions by the US government and be added to any of the sanctions list, the primary one being OFAC's list of specially designated nationals. So Isabel, if you could move forward to the next slide. Just quickly, I thought I'd do a little bit of crystal ball on maybe sort of potential changes or things that we're going to be watching in economic sanctions under a new administration here in the United States. And really, it is crystal ball because we don't know. Certainly, there are a lot of competing demands and priorities. And the one thing about economic sanctions is that it is a foreign policy tool. So it's a very dynamic area, it's changing frequently, and there are lots of different levers for the US government to pull and change and modify. So really, it can be a reaction to various geopolitical things that are going on in the world. But here, just programs that have had a lot of activity recently, and we expect to continue to see more, certainly would be the sanctions against Venezuela. In Russia, we have targeted sanctions against individuals and entities and sectoral sanctions that limit US people from engaging in certain types of activities with named individuals and entities. Iran will be interesting to watch. Certainly we now are in a situation where the US sanctions diverged from the EU sanctions. We're actually fielding a lot of compliance questions from European clients who have certain activities and are trying to understand, if they're going to have issues under US sanctions, even though the activities would be permissible under EU regulations. So again, that's sort of an interesting space to watch. Cuba, this one will be really fascinating. It could be that, there's just not much change for a while. It could be under a Biden administration that it's a reversion to Obama era regulations and licensing policy. I mean, there's not a lot of change that can happen as long as the embargo is in place. But around the edges on those regulatory and licensing topics, there could be some modification. The other thing that we'll be interested to watch is the Helms-Burton causes of action under Title III. So this is a portion of the Helms-Burton legislation from 1996 that had been continuously waived by successive US presidents up until Trump. And just in the last couple of years, it gave a private cause of action to certain US claimants against persons determined to be trafficking and confiscated Cuban property. That is, there's not much case law. There have been a number of cases filed, but we don't really have a lot of precedent to go on. And so there are pending cases that have yet to be resolved, lots of constitutional questions at play. And it's unclear whether Title III will continue in effect or whether under a new administration, potentially that provision would be waived. And so we would have this sort of interesting pocket of cases that were brought while the waiver was suspended. A waiver is waived, but then go back to sort of a waiver situation where Title III cases can't be brought. Another note on Cuba that I don't have on here is Title IV under Helms-Burton, which has been in effect and continues to be in effect. And this is not a private cause of action, but this is a provision that the State Department, the US State Department can invoke to restrict, deny, revoke visas by non-US persons traveling to the United States who are executives of non-US companies that are engaged in business in Cuba. It's been utilized a few times. We're kind of watching with interest to see if it's going to be invoked in connection with any of the Title III causes of action, but I don't actually expect to see changes to Title IV. Again, this is sort of a crystal ball thing. That's probably something that'll stick around. I think we should go ahead and move to the next slide. I want to make sure I've got some minutes to talk about CFIUS. So Isabel, you can go ahead and progress it. Thank you. So the Committee on Foreign Investment in the United States is a multi-agency committee. It's chaired by the US Department of the Treasury. We call it CFIUS for shorthand. And CFIUS has been around for decades, and actually the legislation has been around for decades. We've had some changes over the last 10 to 15 years in the form of 2 new large pieces of legislation that both had broad bipartisan support in Congress, which for those of you who are legislation watchers in the United States, you know that can be pretty hard to come by. So the CFIUS legislation, and now through a series of implementing regulations, we have effectively a new foreign investment national security review regime. I have no expectation that that will change at all under a new administration because of the history and because of the broad bipartisan support that these measures have had. I will say that the nuance here would be, and where there could be change, has more to do with not the framework for what is being reviewed, but what are considered to be national security concerns or nationalities of investors that present a national security concern. And there, that is really up to the discretion of the agencies doing the review. That's not something that's dictated through the legislation or the regulations. So that could differ over the years. So what is CFIUS? Why does it matter? At the end of the day, the US president has legal authority to block or unwind foreign investment in the United States that is considered to have unmitigated national security risks or presents a threat to US national security. So the sort of practical approach for years has been for parties to an investment, to a acquisition historically, to notify the committee, have a review completed, and then if all goes to plan, CFIUS actually issues a safe harbor letter, which says we've reviewed the transaction, all the member agencies have reviewed, and we find no unmitigated national security issues. It's possible that that the agencies require some sort of mitigation of the foreign ownership or control, but now, and Isabel, if we could move forward. What sort of the biggest change has been over the last couple of years with the new statute and new regulations are that we have a situation where not just an outright control transaction where we have a foreign investor acquiring a US business is in scope for CFIUS review, but now even some instances of minority investment can trigger CFIUS review. And historically, the review has been a voluntary process where the parties submit. We now have a subset of particular types of investments, even minority investments, certain ones, depending on the nature of the US business and what types of access rights the foreign investor has, that trigger a mandatory declaration to CFIUS. And failure to file the mandatory declaration can result, not only you have the sort of potential consequence of the investment being blocked or ordered to be unwound, it's also subject to civil penalties up to the value of the investment. So it's very important to, as Antonio said, sort of at the outset in the introduction, now we really need to triage all foreign investment in the United States. And this is something that we're doing regularly since the regulations came online, to first of all determine, do we need to do a mandatory declaration? And it would be a joint submission by the investor and the target of the investment. So it's very important for the parties to be aligned about it, and also to be thinking about it from a timeline management standpoint, and also a cost standpoint, and quite frankly, from a deal valuation standpoint. We've seen some situations where a CFIUS notice actually, not just the notice itself, but sort of the mitigation measures that the US government wants to see actually impact the value of the investment. So it's really important to be aligned and thinking about that up front. The last couple of points I'll make here on this slide, and then I can stop. I want to make sure we have enough time for handling questions, is that the basic concept of CFIUS being there's a concern about foreign investment in the United States. It's a little bit of a misnomer in the sense that it's possible to have non-US to non-US investment that could trigger CFIUS. So how does that happen? If there's a foreign investment, let's say a Spanish investment in an Italian company or an acquisition of an Italian entity, If that Italian entity has US operations, US assets, US subsidiaries that are part of the acquisition, those need to be considered in scope for CFIUS, and that sort of analysis on CFIUS notification and that triage should apply to the US assets and the US business. It's also important to note that there's no de minimis value threshold. This isn't like antitrust competition reviews, Hart-Scott-Rodino, where there's a deal value that triggers. There's no floor and no ceiling, and it's very much a case-by-case looking at, is there a non-US investor, even indirect? CFIUS is concerned about all the way up the organizational structure. So simply having a US acquisition sub making the investment is not going to change the CFIUS analysis. We're going to look all the way up that organizational structure to ultimate beneficial owners, quite frankly. It's also going to be really important to understand and to know what is the nature of the US target of the investment, because the primary analysis for whether a mandatory CFIUS notice is required has to do with the technologies and the business of the US target. For example, if they're dealing in export controlled technologies, not just in commercial products that they're selling or exporting or providing to the US government, or to customers outside the United States, but even things that they're using themselves as tools, on the idea that a foreign investor, once investing or acquiring that entity, could have access to those technologies. So that is a national security concern, and certainly any US targets that have business dealings with the US government, are performing US government contracts, hold security clearances, or doing classified work, those are very much in scope as well. But even low tech industries like food supply chain, more so even in the last 9 months, basic medical supplies and medical devices may be considered national security related. So it's really important to think broadly and expansively about what might be in scope, and we're happy to help with that effort. So I'll stop there, and Juan Carlos, if you have questions or want to open up the floor, I'll leave it to you.
Yes, thank you so much, Kara, and thanks everyone else for this great presentation. Well, we touched many interesting points. So yes, we are opening now the time for Q&A, for questions. So anyone that would like to send a question to any of our panelists, please do so through the control panel that you might see on your right side of the screen at the tab that says questions. You just need to click there and send your question, and we will address your question right away. So we have already some questions that I would like to share with the panel. So let's start with the first one that we got today. So the question is, for a US citizen that have never lived in the US, but in Spain, so it seems that have a dual nationality, and yet never have filled taxes in the US, I was told that you can ask for a first forgiveness. But the question is there a benefit for me to do that before then I decide to move to the US, or it doesn't provide me any specific benefit living in Spain at the current time? And also include a second question when it asks, since all my incomes just come from my job in Spain, in case that I start presenting taxes in the US and also in Spain, who should I finally pay? So
okay, I'll jump in there. That's a lot of questions, kind of a lot of information in one, but generally, if you are a citizen of the US, even if you don't live here, and you've never maybe really lived here or spent significant time here, you are required to comply with the same requirements of filing and paying taxes as a US citizen that lives in the US. So in that case, there definitely is a requirement to be filing and paying taxes. There are programs that the IRS has available right now to help people that are in a situation like that to normalize and to start filing in the US, because this is someone that has never filed, so there could be penalties and all sorts of issues going back many, many years. So there are programs that the IRS has available to people to in order to normalize. There is not anything that is just like that's not quite how the programs work, but there are different programs that are available that can be very beneficial in reducing the amount of taxes that you owe and any penalties that you owe. And then depending on this person's situation, because there sometimes can be criminal liability for not having filed taxes in the US, there is some programs that can actually help alleviate the criminal liability. The reason that you would want to come forward and go into one of those programs willingly is that if the IRS or realizes that you're not paying, and they come after you and they issue you notices or they start auditing you, you're actually no longer eligible to go into the programs. And then you're kind of going to be at the mercy of the IRS for them to decide how much they're going to charge you. And then the other question, I guess, is, some people, it's like, well, are they ever going to find a way to comply with the rules? And the answer is, in this day and age, it is possible. I mean, any bank that you go to and try to open a bank account, most of them are going to ask you where you're born. If you were born in the US, they're going to know that you're a US citizen. And if you're born in the US and you expatriated, so you're no longer a US citizen, they're going to ask you to show that. So when you make certain types of investments, they are going to request for that information. They're going to know that you're a U.S. citizen. And then there are automatic information exchange agreements between the U.S. and Spain, and they will automatically exchange your information with the IRS. So the IRS will become aware of the fact that you are not filing, and then they can actually go, maybe go after you, and then you won't be eligible for these programs. And really, for a Spanish person to start filing, the reality is if you're living in Spain and all of your income is earned in Spain, most of that income is only going to be subject to tax in Spain. You're not going to have, a lot of that income won't be subject to any U.S. tax, and the only thing that you'll have to do is, is do a filing in the taxes you paid in Spain, since usually Spain has about the same or higher tax rate as the US. And then another option for someone like that, there are some ways that we could actually help you expatriate so that you'd no longer be a US citizen, because maybe you're a Spanish citizen, you're a European citizen, maybe you don't feel the need to really be a US citizen. But you do have to be compliant with 5 years of tax filing to be eligible to expatriate without having a tax. So, whether you can expatriate without being subject to tax, there's a lot of ways you can test that, but I'm not going to. I do think it is important, if you are a U.S. citizen and you haven't been filing, to talk to a tax professional and see what they can do to normalize, because it's better for you to come forward and handle it than for the IRS to come knocking on your door.
Wonderful. Thank you so much, Jeanette. That's been very helpful. Another question that you got right at the moment now. It's, let me check here. Yes. What are the sectors in the U.S. economy where you see greater potential for investment under the current climate?
Well, I mean, I think I'll let my partners jump in there too, but we are, with foreign investors, we certainly are seeing continued investment in U.S. real estate, because I think especially now the values in some markets that had been very high have deflated a little bit. So I've seen some interest go up in investing, say, in real estate. They were considered overly developed, or the values were overly high, so people weren't interested in investing in those markets at the time. So that's been interesting. I think also we're still seeing interest in investing in the tech sector. That I've talked with some clients this week about different tech investments, but that's just, I mean, I deal with a lot of Latin American clients, and I deal with clients in Europe as well. But I think the investment in U.S. real estate has been something I've been getting a lot of questions about, but that's always the case. And I think it's just something that people feel that it's very stable. And so right now, when there's a lot of uncertainty, that's been an interest. But I would turn that over to Yosbel or Kara or Antonio, because they might have different experiences.
The only thing I would add, I totally agree with you on real estate and tech. The only thing I would add to that is specifically for Spanish investors coming into the US, they see the growing Hispanic market in the US as a great way to expand for consumer products, food products. You know, so we've seen investments coming into, you know, Florida, where there are heavy Hispanic populations, you know, Florida, California, and Texas in particular.
Wonderful. Perfect. Thanks so much. Another question that we had is asking, I know this is a simple question with a complex answer, but what is the best way to buy a US company? Using personal assets, individual, or company assets through a Spanish company? Thanks.
Jeanette,
Well, I think there's multiple, I mean, there's different aspects of that. And that's why you end up, when you're looking at those things, working with lawyers that specialize in different areas. But I think, you know, often we would structure that probably through, you know, a corporate acquisition, but or a company acquisition, but if the individual for some reason, you know, desires to have the investment be done personally, it is possible to do that. It depends on how the company in the US is structured. One thing I also didn't get to talk about is US estate tax issues. So when you're talking about an individual, a non-US individual, owning assets in the US directly in their own name, you can actually have US estate tax exposure because those assets are considered US situs located in the US, and those types of assets are subject to US estate tax even when they're owned by an individual, even when they're owned by a non-US person. And the exemption for non-US people for US estate tax is only $60,000. So if you're invested in a US company, depending on the type, you could have directly in your own name, you could have US estate tax exposure. And then the other issue is that, you know, you may have a requirement for that individual to personally file a tax return in the US, which a lot of non-US people don't want to do. You may also have, you have different tax rates. So right now, corporations in the US are subject to lower tax rates, or might have, and if they're US and may engaged in activities here. And in the case of a Spanish corporation, they may have a reduced withholding amount on any payments that come out of that company. So I would say, you know, speaking in generalities, I probably would lean towards using some type of company structure to invest into the US operations. But of course, there's never, you know, it always can be done in multiple ways depending on the circumstances. I don't know, Yosbel, if you have anything you want to add.
No, I completely agree with you.
Wonderful, thank you so much. Another question that we got, it's a company like TikTok, the TikTok US subsidiary, an example of a company that had to present a declaration for CFIUS. Are you aware that they did that when they created the company?
Well, I can't really speak to the sort of notices that companies have gone through previously. CFIUS notices are actually not a matter of public record, and they're not subject to Freedom of Information Act requests. So really the only way that we learn about previous CFIUS filings or review is through either press releases, or in some cases where companies are trading publicly in the United States through their SEC disclosures. And the other thing we can sort of make a negative inference is that when there are companies who are ordered to divest or unwind, the inference is that they did not go through the review. Because if they had gone through the review, they would have received a safe harbor letter that said that particular investment had no unmitigated national security concerns. So another sort of interesting evolution in the CFIUS regime is that apart from these sort of investments where there is a concern about the nature of the target's business and access to sensitive technologies, or now part of what's in scope are companies that are maintaining personal identifier information or personal information of US citizens, particularly if those US citizens happen to be US government employees. Another area that is now very clearly articulated in the regulations, and I just wanted to pick up on Jeanette's point as well, is real estate. So even situations where the investment or the acquisition itself does not relate to sensitive technologies, there could be a situation of what we call physical proximity, where a real estate target of investment is situated in a sensitive location or close to sensitive US government sites. So that's another thing to think about, but that is something, and just sort of looping back to the TikTok question, that can be relevant also in these situations where deals are ordered to be unwound.
You know, the only thing I would add to that is that, you know, we're speaking to an audience of Spanish investors, and I think that the CFIUS threat level from a Spanish investor is going to be way low. So the best thing to do is to just go ahead, make your filing, get through the 30-day waiting period or whatever it is, and then you don't have to worry about it ever again, because the likelihood that the US government is going to say that a Spanish investor is a threat is extremely low. Now, if you were, you know, a Russian investor or, you know, a Chinese investor, that would be obviously a different consideration. So call Kara, file the paperwork, and then you don't have to worry about it.
Exactly. And just to that point, we have to think about foreign investment from any nationality being in scope for CFIUS. And to Yosval's point, when the notice is under review, what kind of scrutiny is it going to receive? And I agree 100% that in general, you know, that an investor from Spain is not going to be perceived to be a significant national security threat, but they're going to review everything case by case, and you know, it would be in scope. So
wonderful, thank you so much. Another question that we got, it says, what about a Spanish citizen that always worked in the US and paid taxes to the US for the income generated in the US? Is a Spanish citizen that does not live in Spain required to pay taxes in Spain?
Oh, I'm not a Spanish tax lawyer. I think the answer probably you have to ask a Spanish tax lawyer, but generally how the tax treaty would work is that you would be paying the taxes here and you wouldn't be having to pay them in Spain. There could be some type of income that you're receiving from Spain, for example, that you have to pay, but usually how that would work is that they would be paying the income tax here, and they would not have to pay in Spain, or they would get a credit for the taxes they pay here. And the only reason they might have to pay in Spain is if they have, Spain has a higher tax rate than we do. But that really is a question for a Spanish tax advisor, which I can recommend somebody if you don't know anybody, because I do work with tax lawyers in Spain, but we would have to loop in local counsel, which is something that I do very frequently, because we have to collaborate with tax lawyers and other lawyers in the jurisdictions that are involved.
Yes, thank you. I just would like to add that in Spain, there's no, like in the US, that for just being a US citizen, you are obliged to pay taxes in the US. In Spain, it's not that way. It depends on the number of days that you spend in Spain to determine if you need to pay taxes there or not. So that's another thing that needs to take into account. Well, we have time for a couple of questions more that enter here. And one of it's, have you seen a constant flow of Spanish investment into the US in the last few years? If so, what are the main sectors?
We talked a little bit about that, but I think Antonio would agree with me that outside of sort of big Spanish companies, right? So everyone can think of companies like Telefonica, for example, that is a worldwide player. the inflow of Spanish investment into the US, I think, really peaked in the 2008-2009 crisis and its aftermath, right? Because even PYMEs, small to medium businesses, started seeing their market share within Spain and really all the problems that Europe was going through. And then they looked at the US market, right? You have 350 million people. You have this like growing base of products that are familiar to us or to our parents, for those of us who are Hispanic. And I really saw a big influx. I will tell you that the other big influx that happened were infrastructure projects. There were a number of infrastructure companies that came to the US looking to do the type of deals that they were doing in Spain, public-private partnerships, which is a very common model in Europe and in Canada. And I think it just became challenging too, because you have to remember that the US is a collection of 50 different jurisdictions, all within the same. So what happens in California is very different than what may happen in Florida or Texas. But I think we talked about those general areas.
Thanks. Wonderful. If you like, last question that we got until now, and being here at the Spain-US Chamber of Commerce in Florida, it's a very, very good question. It's should Latin America be considered as part of an investment strategy in the US by a Spanish or European company?
So I think that Miami is where it is because we do provide that bridge between Europe and Latin America. Almost every client that we've seen come from Spain at some point goes down into Latin America as well. Supermarket chains that buy products and are splitting the border and now crossing into Mexico, for example, or technology companies that are looking for investments in places like Colombia and Chile and Brazil. So I definitely think that Spain obviously has its own very deep connections to Latin America, and in fact sometimes we structure investments in Latin America through like a Spanish but I definitely see that for us, and in fact in our practice we consider it the Latin American and Spanish practice because there's so much commonality to it. We've also seen, for example, law firms that have started a lot of the Spanish law firms, right, have gone into Latin America as well because there's such a close contact there.
From a tax perspective as well, there can be benefits because Spain has tax treaties with a lot of Latin American countries, and the US only has a tax treaty with Venezuela and Mexico. So when you're structuring your investments in the US or US into LATAM, a lot of times Spain is a really important anchor point because there's treaties between all the jurisdictions, Spain being the jurisdiction that has the treaties with US and LATAM, and so we benefit from a tax perspective when we're structuring the investments.
Yeah, I think if I'm not mistaken, it's been a couple of years since we looked at this investment, but the only country that really, like, if you have U.S. investors and European investors, Spain is really the portal to places like Argentina, for example.
Mm-hmm. Oh, perfect. Wonderful. I think we cover all the questions sent by the attendees. So we can finish for the day. And again, I remind everyone that this presentation will be shared, and also the video will be shared with everyone, so you could watch it again or share with friends and colleagues. And also the contact information of all the panelists will be shared so that you could address your questions directly to them and discuss any further comments that you might have. Again, thank you so much, Greenberg Traurig, for being with us today. Thank you, Jeanette. Thank you, Kara. Thank you, Josbel, and thank you, Antonio, for being with the Spain-US Chamber of Commerce once more. We hope to see you again, not very far away, maybe at the beginning of next year, to address another interesting topic that might be interesting for all our members. So thank you so much for being with us.
Thank you, Juan
Thank
Carlos.
you.
Thank you.
So have a great day, everyone, and thank you for being with the Spain-US Chamber of Commerce today. Have a great day.